This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
If you're 25 years old and your boss fires you simply because, they think you're too young for leadership, federal law actually says you were completely out of luck.
Yeah, the federal government will not help you there.
Right. But under Florida law,
yeah,
you might actually have a winning discrimination lawsuit on your hands.
Oh, absolutely.
So, welcome to the Invisible Lines of the Employment Rulebook. Today's deep dive is tailored specifically for you, whether you're a legal strategist, a manager, or just a deeply curious learner looking to decode the exact mechanics of Florida employment law.
Because we are unpacking a highly specific and occasionally contradictory set of rules today. I mean, employment law isn't just some theoretical puzzle debated in law school symposiums. It dictates the daily realities of hiring, firing, and basically just workplace survival.
Yeah, exactly. And we are drawing from an excellent series of legal plain language summaries provided by Bach Pro Se. And before we get any further, let's actually establish a vital ground rule for our listener regarding that source name. It is pronounced pro se. Rhyming with day, never proceed.
I am so glad we're clearing that up right off the bat because mispronouncing Latin is, it's the fastest way to lose credibility in a courtroom.
Oh, 100%.
Yeah.
So our mission today is to translate these really dense Florida statutes into a practical roadmap, looking closely at the Florida Civil Rights Act of 1992. But before a worker can even think about filing a claim, we have to figure out if they're even, standing on the playing field. Because the state doesn't just apply these rules to every single business, no matter how small.
Right. No, they don't. The legislature intentionally built a shield for very small operations. So under Florida Statute 760.2, subsection 7, the Florida Civil Rights Act only kicks in if an employer has 15 or more employees.
Okay, 15.
Right, but the calculation for that threshold is actually very specific. The employer has to have those 15 people on the payroll for each working day in at least 20 calendar weeks in the current or preceding year.
Okay, let's unpack this a bit. 20 calendar weeks. What about, part-time workers?
Yes, part-time workers do count toward that total, but independent contractors do not.
Ah, okay. Which makes perfect sense when you think about Florida's economy. I mean, you have a ton of seasonal businesses, beachfront cafes, agricultural operations.
Exactly.
They might staff up to 20 people for 2 months out of the year, but then they drop down to 4 people in the off-season. So that 20-week rule essentially ensures that only established year-round operations are really burdened with the complexities of state civil rights litigation.
That's exactly it. It separates the true mom-and-pop shops from entities that have, enough structural capacity to handle actual human resources compliance. But once a business hits that permanent 15-employee threshold, they are fully bound by Florida Statute 760.10, subsection 1, which is the core provision outlawing discrimination.
Right, the big one. Now, our listener probably already knows the standard protected categories. We're talking about race, color, religion, sex, pregnancy, national origin, and handicap. Which, by the way, Florida still uses that term instead of disability.
Yeah, they do, though the courts interpret them basically the exact same way.
Okay, good to know. And then marital status is in there too. But where this gets absolutely fascinating is how Florida deviates from the federal giants, like Title VII, the ADA, or the ADEA.
Yeah.
Let's go back to that 25-year-old from our intro.
Yeah, that's a perfect example because under the Federal Age Discrimination and Employment Act, the ADEA, the legislative priority was very specific. They were protecting older workers who were being pushed out of their pensions or, just aged out of the workforce.
Right.
So federal law only protects workers who are 40 and older.
Wow. But Florida's different.
Very different. Florida took a much broader textual approach. The state statute simply prohibits discrimination based on age. Just age. It doesn't put a floor or ceiling on it.
Wait, really?
Huh.
So under Florida law, a 25-year-old could theoretically sue for age discrimination if they were fired for being too young, but they couldn't do that under federal law.
Exactly. If that 25-year-old is denied a promotion solely because management thinks they have a quote-unquote baby face, despite having, the best sales numbers in the region, that is an actionable claim under state law.
That is wild. The friction that must cause for corporate HR departments operating across state lines is incredible.
Yeah.
I mean, a policy that is perfectly legal in Georgia might trigger a massive lawsuit the second it crosses the Florida border.
Yeah, the border makes a huge difference.
And age isn't the only deviation, right? Because Florida law explicitly protects marital status, too.
Right. So if a company decides they only want to hire single people who can travel 300 days a year, or conversely, if they fire someone because they just went through a really messy divorce, Florida law provides a shield for that.
Yeah.
Federal Title VII does not explicitly carve out marital status.
Right. And then the landscape shifts even more dramatically when we look at how the two systems handle sexual orientation and transgender status.
Yeah, this is a major divergence. Under federal law, the United States Supreme Court has interpreted the word sex in Title VII to inherently include sexual orientation and transgender status. It's a very broad, case law-driven interpretation.
Right.
But Florida's statute lists sex and pregnancy as distinct categories, but it completely omits any explicit mention of sexual orientation or transgender status in its actual statutory text.
Oh, wow. So a plaintiff's attorney drafting a complaint in Florida has to be incredibly strategic about which system they're invoking.
Absolutely.
Because if you rely purely on the plain text of the Florida statute, you are facing a much different, arguably more restrictive landscape than if you invoke the federal case law.
It's a completely different playing field.
Okay, so let's say our worker is definitely protected. They work for a 50-person company, and they were fired based on a protected category. What is the actual blueprint for seeking justice? Because knowing your rights is basically useless if you get kicked out of court on a technicality.
And the technicalities are where most cases live or die. Because in employment law, the clock is your biggest adversary.
Right.
Under Florida Statute 760.11, subsection 1, a person aggrieved by a civil rights violation cannot just march down to the local courthouse and file a lawsuit against their boss. You are legally mandated to exhaust your administrative remedies first.
You have to go through the agency.
Yes. You must file a formal complaint with the Florida Commission on Human Relations, the FCHR, and you have to do it within exactly 365 days of the discriminatory act.
1 year, 365 days. So if the firing happens on January 1st and you file your paperwork on January 2nd of the following year,
your state claim is completely dead, barred permanently.
oh man.
And the strictness of that deadline catches a lot of people off guard because they might spend months trying to negotiate a severance package or, waiting for internal HR appeals to wrap up.
Yeah, that makes sense.
But the statute does not care about internal company appeals. The clock starts ticking the exact moment the adverse action occurs.
Well, wait, if this employee is trying to preserve their federal rights too, they would normally have to file with the federal agency, the EEOC, right?
Yeah.
So are they forced to run two separate, highly complex administrative marathons at the exact same time? Like filing paperwork with both Tallahassee and Washington?
Thankfully, no. They are spared from that specific nightmare through something called a work-sharing agreement.
Okay.
The FCHR and the federal EEOC have a dual filing system. So if you file your complaint with the state agency, they automatically dual file it with the federal agency and vice versa. It essentially prevents the government from wasting resources running redundant investigations into the exact same incident.
So this work-sharing agreement is like carbon copying an email to two different managers at once. You do the work once, but both the state and federal government are on notice.
That's a perfect way to look at it.
And because Florida has this referral setup, doesn't it actually manipulate the federal deadlines as well?
It does. It creates a massive advantage for the employee. Because normally, if you live in a state without a local agency, you only have 180 days to file a federal EEOC complaint. But because Florida is a referral state with this work-sharing agreement, dual filing extends that federal deadline out to 300 days.
Oh, wow. Okay, so our hypothetical worker beats the clock. They file within the 365 days for the state claim. Once the FCHR receives that paperwork, the sources outline a very rigid flowchart of what happens next. The agency doesn't just sit on it forever.
Well, theoretically, they don't. Under Section 760.11, subsection 3, the FCHR has a statutory window of 180 days to investigate the complaint and make a determination.
Okay, 180 days.
Right. They request documents from the employer, they might conduct interviews, and then the path essentially splits. Let's call the first route Path A. This is where the agency finds reasonable cause under Section 760.11, subsection 4.
Meaning they think something illegal actually happened.
Exactly. They look at the evidence and conclude that, yes, discrimination likely occurred. At that point, the employee is given a choice. They can request an administrative hearing, or they can take that finding and file a civil lawsuit in a standard court.
Okay, but if they find reasonable cause, The opposite must also be true. Path B is where the investigator looks at the emails, looks at the performance reviews, and says, we don't see any discrimination here. They issue a no-cause finding.
Right.
And if the state doesn't find cause, I imagine they want to wash their hand of the case as quickly as possible. The window to appeal that must be pretty tiny.
It shrinks down to a mere 35 days.
35 days, that's nothing.
It's incredibly fast. Under Section 760.11, subsection 7, if the FCHR dismisses the complaint with a no-cause finding, the situation becomes an absolute emergency for the employee. They have 35 days from the date of that determination to request an administrative hearing, and if they miss that 35-day window, their state claim is permanently barred. The legislative logic is ruthless but efficient, The state has limited resources and they just want to quickly clear their docket of claims the agency has already deemed unsupported by evidence.
35 days is practically nothing in legal time. By the time that letter arrives in the mail, you find a lawyer who is actually willing to take a case the state already rejected, and you draft the petition, that window is slammed shut.
Very difficult.
It acts as a massive filter to weed out say, litigants or legally weak claims. But here's where it gets really interesting. What about a third option? Because state agencies are notoriously underfunded and overwhelmed. What happens if they just never get to it? The 180 days pass, and the FCHR has made zero determinations either way.
That brings us to Path C, which is governed by Section 760.11, subsection 8. This is a built-in release valve for administrative inaction.
Okay.
If the FCHR fails to make any determination within those 180 days, the statute allows the employee to proceed exactly as if reasonable cause had been found.
Wait, so if the government agency gets overwhelmed and just drags its seat for 6 months doing absolutely nothing, that inaction actually gives you the green light to take your boss to court?
That is exactly what it means. The legislature is basically saying that an employee's right to seek justice shouldn't be held hostage in administrative purgatory indefinitely.
Wow. Okay, so let's fast forward. The employee gets the green light, and they are finally standing in front of a judge. Proving discrimination on paper is one thing, but proving it in reality is incredibly difficult because, nobody sends an email that says, I am firing you because of your religion.
Right. It's the central challenge of employment law. You have to prove causation. You must prove the adverse action occurred because of the protected characteristic. And because direct smoking gun evidence almost never exists, Florida courts utilize a burden-shifting framework established by the federal Supreme Court known as the McDonnell Douglas standard.
McDonnell Douglas. A burden-shifting standard. How does that practically play out in the courtroom? Like, who has to prove what and when?
It's a three-stage process. First, the employee bears the initial burden to establish a prima facie case, basically the basic facts.
Okay.
They have to show they belong to a protected class, they were qualified for their job, they suffered an adverse employment action, like being fired, and they were replaced by someone outside the protected class, or they were treated worse than a similarly situated colleague.
Right.
Once the employee lays that foundation, the burden of proof shifts over to the employer.
So the employer can't just sit there in silence. They are forced to present a legitimate, non-discriminatory excuse for the firing. They have to say, well, we fired this person because they missed 3 major client deadlines and cursed at a vendor.
Exactly. And this is where the final, most critical shift occurs. The burden drops back onto the employee to prove that the employer's stated reason is a pretext. And a pretext is just a legally acceptable excuse manufactured to cover up an illegal motive.
So it's like a highly aggressive tennis match.
Oh, I like that. Yes.
You serve your basic claim over the net. The employer volleys back with a perfectly legal, documented excuse for the firing. And the entire match is decided by whether you can hit a winner, proving their excuse is a total lie.
Yeah.
If the employer says they fired you for being late, you have to show the court that 5 other people outside your protected class were late just as often, and none of them were fired.
Exactly. But that requires finding a perfect comparator, someone who is nearly identical to you in job title, disciplinary history, and performance, but who doesn't share your protected characteristic.
That sounds nearly impossible.
It often is. Courts recognize that in modern, complex workplaces, perfect comparators rarely exist. That is why Florida allows an alternative evidentiary standard known as the convincing mosaic.
The convincing mosaic. It sounds like an art history term, but legally, it's basically a lifeline for plaintiffs who can't neatly fit their case into that McDonnell Douglas tennis match, right?
Precisely. It allows an employee to survive summary judgment, meaning they actually get to take their case to a jury.
Oh, nice.
If they can present enough circumstantial evidence that, when pieced together like tiles, creates a compelling picture of discriminatory intent. So a single tile might be an ambiguous comment from a supervisor. Another tile might be a sudden, unexplained drop in performance reviews after 10 years of stellar evaluations.
Right.
And a third tile might be highly suspicious timing. None of these pieces alone are a smoking gun, but arranged together, they tell a clear story of bias that a jury should be allowed to evaluate.
That makes a lot of sense.
Yeah.
So proving discrimination is all about building that mosaic or winning that burden-shifting match.
Yeah.
But what if you aren't the primary target? What if you are the bystander who reports a manager for creating a toxic environment and you get fired for speaking up?
Retaliation.
Yeah, we need to talk about retaliation because Florida actually splits this into two entirely separate, very different legal paths.
Yes, Florida maintains dual systems for retaliation. First, there is the Florida Civil Rights Act retaliation provision under Section 760.10, subsection 7. This is highly specific and quite narrow. It only protects an employee if they are opposing unlawful discrimination based on those 9 specific categories we discussed earlier, race, sex, age, handicap, and so on, or if they are actively participating in an FCRA investigation.
Okay, so let me get this straight. If I go to HR and report that a vice president is sexually harassing an intern and the VP fires me for reporting it, I am protected under the FCRA.
Correct.
But what if I discover the VP is dumping toxic chemicals into the local river or embezzling money from clients? I mean, that has nothing to do with civil rights or discrimination.
For those scenarios, we leave the FCRA entirely and look to the Florida Whistleblower Act, specifically Section 448.102, subsection 3. This provides much broader protection. It shields employees who object to or refuse to participate in an employer activity, policy, or practice that is in violation of a law, rule, or regulation. That covers environmental dumping, OSHA safety violations, financial fraud, and far more.
And procedurally, this operates on a completely different track, doesn't it? Because earlier we established that for a civil rights claim, you absolutely must file with the FCHR and wait up to 180 days.
Right, but the Whistleblower Act bypasses that administrative hurdle completely. Under Section 448.103, subsection 1A, an employee alleging whistleblower retaliation does not have to file with the FCHR. They have the procedural advantage of filing a lawsuit directly in civil court.
Straight to court with broad protection. That sounds incredibly powerful for an employee.
It is.
But knowing how strict statutory interpretation can get in Florida, I am guessing the courts have placed some heavy guardrails on who actually qualifies as a whistleblower. I mean, our sources highlight a massive shift that just happened recently.
What's fascinating here is how quickly the landscape changed. The landscape of whistleblower law was functionally rewritten overnight in May 2026.
Wow.
The Florida Supreme Court handed down a pivotal decision in a case called Gessner v. Southern Company. Prior to this ruling, many appellate courts operated under the assumption that an employee was protected if they had a reasonable, good faith belief that the employer was breaking the law.
So let me make sure I'm following. If I saw a wire fraying near a puddle on the factory floor and I genuinely believed it violated OSHA electrical standards, I was protected from being fired for reporting it, even if I couldn't cite the exact subsection of the Federal Safety Code.
Under the old standard, yes. But in Gessner, the Florida Supreme Court applied a strict textualist approach. They looked at the plain language of the statute, which says the employer's activity must violate a law. It does not say suspected of violating a law or reasonably believed to violate a law.
Oh.
So the court ruled that to claim protection under the Whistleblower Act, the employee must prove the employer committed an actual violation of a law, rule, or regulation.
Stop and think about the real-world friction that creates.
Yeah.
So let me get this straight. If I complain that the factory floor is violating OSHA safety rules and I get fired for complaining, I have to prove in court that they actually broke the OSHA law. If I was just reasonably mistaken about the exact safety statute, I have zero whistleblower protection.
That is the precise reality of the Gessner decision.
That is wild. If a nurse reports a hospital for what she thinks is a violation of patient-to-staff ratio laws, and she is fired the next day, she had to go into court and legally prove the hospital actually violated the statute.
Right.
And if a judge determines that the hospital staffing levels were dangerous and unethical,
Right.
but didn't technically meet every single legal element of a statutory violation, that nurse has zero whistleblower protection. Her firing is entirely legal.
It's entirely legal. The court's reasoning is that employers have a fundamental right to manage their workforce and fire at will employees without facing retaliation lawsuits over conduct that isn't actually illegal.
Wow.
But the practical effect is that an employee essentially has to act as an amateur attorney, performing a flawless legal analysis of a situation before they dare lodge a safety or compliance complaint. You have to be 100% correct.
The chilling effect on internal reporting must be massive. Well, let's look up the final piece of the puzzle here, the bottom line. Let's assume an employee navigates the 365-day administrative deadlines. They successfully build their convincing mosaic of discrimination, or they prove an actual violation as a whistleblower, and a jury actually sides with them. What does justice physically look like under Florida law? What do they get?
The remedies for discrimination are codified in Section 7, 60.11, subsection 5. A judge can order affirmative relief, which includes forcing the company to give the employee their job back. The court can also order back pay to cover lost wages, compensatory damages for emotional distress and mental anguish, and crucially, attorney's fees.
Attorney's fees are the engine that makes this entire system run, honestly. Because without the possibility of recovering fees, a wrongfully terminated unemployed person could never afford a multi-year battle against a corporation's legal team.
Right, it levels the playing field. But these damages aren't unlimited. Private employers get some significant legislative shielding.
Like what?
Well, there are strict statutory caps. If an employer's conduct is particularly malicious or reckless, a jury might want to award punitive damages to punish the company. However, under the FCRA, punitive damages are absolutely capped at $100,000.
Oh, wow.
And it doesn't matter if the defendant is a local hardware store or a multi-billion-dollar multinational conglomerate. The punishment maxes out at $100,000.
So what does this all mean? The punitive damage cap is basically a $100,000 speed limit on how hard a judge can punish a massive corporation, no matter how egregious their behavior was. I mean, for a massive global corporation, $100,000 isn't a deterrent. It's practically a rounding error. It just becomes the cost of doing business to get rid of an employee they don't like.
It is a deliberate legislative balancing act. The state wants to deter discriminatory behavior, sure, but it refuses to allow a single rogue manager's actions to result in a multi-million-dollar verdict that could literally bankrupt an entire enterprise.
Right.
And there are also temporal limits on back pay. Under Section 7, 60.11, subsection 9, no matter how long the litigation drags on, a plaintiff cannot recover back pay for any period more than 2 years prior to the date they filed their initial complaint with the FCHR.
Okay, so private employers get that $100,000 shield on punitive damages and a strict timeline on back pay.
Mm-hmm.
But what if the employer is the one writing the laws? I mean, what if a worker is suing a state agency, a county government, or a city? How does the government protect its own pockets?
Government entities possess the ultimate shield, which is sovereign immunity. Under Florida statute, the 768.28 subsection 5, damages against the state or its subdivisions are severely capped.
How severely?
Depending on the exact circumstances, total tort liability is often restricted to $200,000 or $300,000. And you cannot recover punitive damages against the government at all.
Oh, wow.
Yeah, so if a jury awards you $1 million against a state agency, you will only see that fraction allowed by sovereign immunity unless the Florida legislature steps in and passes a specific, highly rare claims bill just for you.
That is incredible. You know, when you lay all of these pieces on the table, Florida employment law reveals itself not as a straight line to justice, but really as an intricate maze. You are balancing overlapping state and federal rules, navigating the ruthless 365-day filing deadlines and those tiny 35-day appeal windows, and attempting to prove intent through a convincing mosaic of circumstantial tiles.
And every move is heavily scrutinized. Which really leads us back to the most profound shift we've discussed today, the May 2026 Gessner decision. If an employee now has to be 100% legally correct that a violation occurred to be protected from retaliation, how many workers will simply choose to stay silent about potential safety hazards or unethical practices out of fear they might be misinterpreting the law?
Yeah, it fundamentally changes the calculus of speaking up. I mean, the invisible lines on the board have shifted again, and you have to wonder how many pieces are just staying frozen on their squares. Thank you for joining us on this deep dive into the mechanics of Florida employment law. Keep questioning the rules of the board, stay curious, and as always, stay well informed.
This episode was produced by Bach Pro Se. Run your own legal research at prosay.tribach.com.